Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the Recovery Addict, and boy do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
They got the wrong guy. The dog was biting him.
He roughing him up quite a bit. There's a lawsuit.
9 out of 10 judges prefer watching the Recovery Addict live stream in their courtroom.
The fireworks are not done.
Now we're getting commentary on the case. Dati mihi Anglican por his verbal Latin.
Is that correct?
Oh, for Trump's sake.
Literally not true.
I didn't ask you to interrupt me.
All right, welcome back to the Court of Public Opinion. I am the Recovery Addict. I hope you had a fabulous lunch, because I did. It was great. Macaroni and cheese, a little bit of leftover pizza, all the good stuff. It was 3 meat, for those who are curious. 3 meat pizza. Marianne, congratulations. You're first in chat this afternoon, which means you, my friends, are going to be punished with internet ownership. Yes, your exuberance for the day has brought you this punishment. You're sentenced to internet ownership for the rest of the day. Everything IP related worldwide will be your responsibility. There you go. And good riddance, I say. If you didn't have it, I'd have to do it. So, this is the civil case brought by the O'Keefe family against Karen Reed and the bars for wrongful death. It is a wrongful death suit. This is we have not covered a civil suit like this in quite a while. I mean, the last big one we covered civilly was the ski case. And no one died in that one. So we believe we believe we've got it all rigged up and everything's going to work properly. But all things can happen. So we'll see what happens here. Just hold tight. We've got things. We covered Maya, but Maya was Maya after Gwyneth Paltrow? I thought it was before. Chat's asking for seats. Just never enough with you. Never enough. Okay, I've got to bounce the seats. They're not working properly. I will bounce on the seats to fix them. Okay, that's how you fix them. But I have to do it on my end. Shut it down and start it back up. Wait for it. We're going to give away points for the first person on the internet, who I think was Laura Olson, possibly. I don't know. We'll see. Nope, it was Bree. Bree, congratulations. Now the seats are working. Okay, I bounced on all the seats, fixed them all. We're ready to go. All right.
Don't put a diplomatic plate on a hoopty.
You don't. You just don't. You don't. I went to the post office. I did not have anything there. So if you sent me something, I either already opened it or it hasn't arrived yet. So Denisha, if you sent the blanket or the plushie doll,
somebody just sent me a video of roaches fighting.
The stuffed animal. The stuffed animal has already traveled to Idaho and is in the care and keeping of the future future parents of my grandbaby, of the future parents of my future grandbaby. Or the parents of my future grandbaby. I don't know how to say that. Anyway, that's where it is. The blanket is here. I'm keeping that one for when the kid comes here. Candy Kiss, this is going to be a Zoom hearing. I believe it's a Zoom. I think that's how it's going to go. We're sort of waiting until they give us the final go-ahead. So we'll get what we get and make it work. Future parents of a future baby is a lot of future. It is, but children are our future. So
I don't like podiums, Your Honor.
Auntie Bev is gone. No. We're going to have O'Shea or O'Shea Hennessy. I don't know what his full name is, but different judge on this one for the, I think it's O'Shea. Judge O'Shea. All right, you're having a baby? No.
Counsel wanted to see me inside back.
I'm going to have a grandbaby, so yes. But no, on the direct, it's once removed. Fair trial. Civil. Here's what we need to talk about civil cases. We are so used to hearing about the standard of evidence that has to be met with a criminal case. Beyond a reasonable doubt. It's drilled into our heads. The highest standard we have in the legal world. Beyond reasonable doubt. It's preponderance of evidence in a civil case, which means basically more likely than not. It's a completely different standard. It is very possible to have somebody who is who's found not guilty criminally, and they are found liable civilly. That is very, very common because of this difference in the how certain we have to be about it. Basically, it's a way lower burden. We might hear some different things as well that might be applicable or allowed in civil, but not allowed in criminal. We'll see if that happens or not. But let's see. We'll have the hearing. It's not going to start till 2, and I'll be monitoring it a couple different ways, doing what we can. So I will let you know. Worst case scenario, I have to listen to it and tell you what everybody says, which is fun, but not fun. Kristen, I just missed it. Did you just delete it? Where did it go? Oh, here it is. I was going to make an RA robot for Lawn Lumber, but he put me on a robot ban. I may need to redesign it and make it for grandbaby RA. Kristen. Oh, my goodness. That would be absolutely awesome. That would be absolutely awesome. Let's see. The RA having a grandbaby is such a blessing. You can spoil them and not have to worry about dealing with the aftermath. Okay, here's the problem. I'm 2,000 miles away. This is a problem. We have to fix that problem, which means either they have to come closer to me or I have to come closer to them. But this is going to have to happen because 2,000 miles is not a visit the grandparents' distance. If that happens, can you use different voices and accents? I'm not very good with accents. But pretty much when I tried to do an accent for a dialect or a different part of the world, I pretty much offend everybody. Both the people I'm pretending to be or trying to be and the people I sound like. I basically offend everyone, so I just don't do accents anymore. Will you please tell your Halloween story? How I nearly became a felon. That's the same story. It just has a different title. It's the sub story on Halloween. Mrs. R.A. and I were out doing what we do, which is give away candy to strangers. Not like the creepy way, but they come to our house and they say trick or treat and we give them candy. It's fun to interact with them and say fun things and, oh, that's a cool dinosaur costume and wow, the Hulk. I never guessed. Don't get angry. All these things, they're fun to do with little kids, right? We had a couple trick-or-treaters. By a couple, I mean 3. I guess you could call them young women, came to our house in, I wouldn't say full costume because there was not a lot to their costumes, material-wise. It was, you've got fishnet stockings and mini skirts and tubes and stuff. There's not a lot there, right? But they came and they said trick or treat. And I don't remember exactly what my words were, but I said something that I had been telling all the kids up to that point who came. And they said, well, if you want a treat, where's my trick? Or something to that effect, right? It was just an innocent little, haha, what are you going to do for me? Well, that's the wrong thing to tell some trick-or-treaters, particularly if they're dressed as hookers, which they were. And they're like maybe 14. From then on, I switched to using loudspeakers and a microphone and going roar into the microphone. I just can't make the jokes anymore because I know that it was so close. It was so close last time. But anyway, that's my trick or treat story. We might live stream Halloweening again trick-or-treating again this year. I know a lot of you, and this is why.
Shame on you, sir.
Yes, shame on me for big time. This is why. A lot of you miss out on Halloween. Either you're in an area where trick-or-treating just isn't done anymore. Like sometimes the community ages out of trick-or-treating. It's just not common. The community might not be one that people feel safe going out, or the time that you're able to watch is not the same. I'm in a community that just for one reason or another has dove in at the deep end and just loves it. Like my street particularly. People come from towns around to trick-or-treat on my street, probably because of my neighbor's decorations, not mine, because mine are Christmas lights. But yeah, they come and trick-or-treat, and we get a lot, and it's nonstop trick-or-treating. Oh, looks like they're getting started. Not yet, but I can't show you this, but it's Zoom. So I'll be watching the main proceeding over there for the Plymouth court. Let me see if we can bring you your feed right here. Let's see. Give me just 1 second to get it pulled up. Got some audio. Sounds terrible.
Counsel, I asked the question that you asked, Counsel. He would like to do status first, then the Rule 12s, but he also said to me if you could check your calendars for trial date. All right. Ms. Crockett, are we good to go? You let us know we're ready.
Sounds awful. I'm going to try to take the top end off this one. Just the sharpness of the paper sound is going to kill me. So. Lots of familiar faces showing up on court there. In court. John's parent, John's mom, his brother, Karen's dad. There's can't see if Turtle Boy's in there. There's Karen. Legal team, we see Alan Jackson. A new team on the other side. So Mr. Wolf.
Court, all right.
Court. Oh, they just bark it out.
Good afternoon, folks. Good job, of course. Now in session. Please be seated.
Good afternoon, Your Honor. Good afternoon. All before the court is 2483 CV 692. This is the case of Paul O'Keefe et alia versus C&C Hospitality, LLC, DBA, CF McCarthy et alia. Case is called for status and for Rule 12 motions. Counsel, please introduce yourself for the record, beginning with Plaintiff's counsel, and if you could state the party you represent as well. Thank you.
Good afternoon, Your Honor. Attorney Mark Diller on behalf of the plaintiffs.
Good afternoon. Good afternoon, Your Honor. Dan Buck on behalf of the plaintiffs.
Okay. Good afternoon.
Good afternoon.
Good afternoon, Your Honor. Damon Seligson on behalf of the defendant, Karen Reed.
Okay. Good afternoon.
Good afternoon, Your Honor. Charles Waters for defendant Karen Reed.
Good afternoon, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. Aaron Rosenberg also on behalf of Ms. Reed.
Good afternoon.
Good afternoon, Your Honor. William Kevel on behalf of Karen Reed.
Got it. Okay.
Good afternoon, Your Honor. Christopher George on behalf of the defendant, Karen Reed.
Good afternoon, Your Honor. Marissa Palladini on behalf of Karen Reed.
Good afternoon.
Good afternoon, Your Honor. David Hassett on behalf of Waterfall Bar and Grill.
Okay. I'm sorry, did you say the Waterfall?
Waterfall, yes, Your Honor.
Got it.
Good afternoon, Your Honor. Attorney Kennedy also on behalf of Waterfall Bar and Grill.
Good afternoon.
Good afternoon, Your Honor. Attorney Rose on behalf of the defendant, CF McCarthy.
Good afternoon. Okay, that's all the counselors. Good afternoon, folks, and welcome everyone to the event for this afternoon. When I was assigned this case last spring, the first thing I wanted to do was try to get a sense of where we all are going to fill in our tracking order and get a sense of what direction this case is going. And in the meantime, it looks like there was a motion to dismiss filed by the defendant. So what I would like to do is go through some of the procedural issues that you see in the case for now. We can talk about tracking order. I do think that it's important to get a trial date established at this point, like we would do with any kind of a wrongful death tort action. So to that end, we'll start with the plaintiff. What do you see as procedural issues? I'd like to get an update on discovery, on how that's all going. Counsel? And then we'll get into the motions to dismiss as a substantive issue. I know there's a lot of people here that want to see what the case is all about, but I think it's more important at least to get an idea procedurally where you stand.
Understood, Your Honor. Plaintiff has served all of the defendants with discovery. All of the defendants are currently late with regard to producing discovery. We have not received any as of yet, or minimal. We have started to get some of the documents from the DA's office, though we are it is significantly deficient at this point. We're still waiting for the records to come in. So we undertook with the stay that we weren't able to get any information, and the DA's office wasn't turning anything over while the criminal matter was pending. So we're still trying to get all the documentation in.
Okay, but just if I can follow up on that, the stay that was issued, Judge White had issued one back in maybe the fall. I had issued one when the criminal trial was ongoing. That was sort of a self-defining 60-day or whichever comes first. So that should be pretty much in the rearview mirror for now, right?
I recognize that, Your Honor. Right. So when the stay was lifted, all discovery was served on the parties or thereabouts.
When you say discovery, we're talking about depositions, documents, notices of depositions, or no?
Only one deposition has been noticed, and it's been tabled because we don't have any documents at this stage.
I see. Okay. So it's really the paper discovery that you're looking for. And when you say the DA's office, that obviously is not the defendants. That's going in a different direction, but you're pursuing that sort of on your own?
Right, but we've also, I anticipate that the defendants have all the same data that was exchanged during the criminal matter, to which we haven't ever received. So we have requested that both from the defendant, and we've requested it from the DA's office.
Okay.
It is coming in from the DA's office in parts, and I anticipate we should have it all within the next 21 days, is my guess.
Okay. All right, procedural issues from the defendants. We can start with you, Attorney Seligson.
Thank you, Your Honor. As we're anticipating the status of this case, it's important to inform the court that from Ms. Reed's perspective, we have affirmative claims that we intend to bring on her behalf. Those claims stem from the same facts that I'd issue in this case. Those claims, Your Honor, are against parties that are not in the litigation at this point, including the Massachusetts State Police, Lieutenant Brian Tully in his personal capacity, Sergeant Yuri Buchanan in his personal capacity, Michael Proctor. Those claims would be in the nature of violations of Karen Reed's civil rights and conspiracy. The claims against the Massachusetts State Police would be negligent training, supervision, and retention of Massachusetts State Police troopers. We also intend, Your Honor, to bring claims, affirmative claims, against Brian Albert, Nicole Albert, Matthew McCabe, Jennifer McCabe, and Brian Higgins, who were the occupants of 34 Fairview Road in Canton on the night in question. Those claims will be in the nature of civil conspiracy, violation of Karen Reed's civil rights, and then a claim against the town of Canton through its police department for negligent failure to secure the garage in the Sally Port. We asking the court's permission to bring those claims in this case because they do arise out of the same nucleus of operative facts. In order for us to fairly defend Ms. Reed in this case, those claims, those parties need to be asserted in this case. What we'd like to ask the court's indulgence for is we have a proposal of how to bring those claims in, given the voluminous nature of this case. That would be 10 additional parties coming in. To do that, we would be alleging that the individuals in the House diverted attention away from themselves towards Ms. Reed, that law enforcement then acting on that diverted attention away from her, because the people in the House were either police or police adjacent who were socially and personally connected. Then they collectively conspired to ensure that what happened in the House was not explored and investigated. And instead, Ms. Reed was wrongfully targeted, maliciously prosecuted, made to face 2 criminal trials for the death of John O'Keefe, and is now facing allegations of wrongful death, all stemming from the same claims. How do we synthesize the process to bring these claims and parties in? What we're asking the court to consider is for us, at the time we file her answer to the complaint, we've got some claims that we're asking to be dismissed. Regardless of how the court decides those, we still have to file an answer on her behalf. Our suggestion would be to file those claims against those parties in the same pleading, serve all of those new parties with that complaint, allow them 30 days, not the normal 20 days, to respond, so the court can have one hearing on whether some may bring dispositive motions, some may file general answers, so that we can then decide how and who is in the case and proceed forward. So I bring that to the court's attention. And I'm happy to brief it so that Mr. Diller can have an opportunity.
Well, at a minimum, you're going to do that. I'm envisioning what the plaintiffs are going to say to this rather extraordinary process, but go ahead. But
that would be, otherwise it's going to be a very unwieldy, delay-inducing process, and we're not looking to do that. This accounts for trying to conserve judicial resources, trying to have a streamlined approach, at the same time making sure that all the claims and all the parties are in this case. The alternative would be for us to file a separate action on Ms. Reed's behalf, alleging these claims, and then move to consolidate immediately with this case, which Your Honor has broad discretion to allow. The point being, the claims should be in this case. They all arrive out of the same facts. They're not separate. And that's essentially what we'd like to do. We'd like to brief that, Your Honor, and have the plaintiffs respond and then proceed from there.
Okay. All right. Let's hear it then from the Waterfall.
Yes, Your Honor. We are in the process of completing written discovery propounded to us from the plaintiff for order of extension until next month. We anticipate that will be completed then. We as well.
When you say an extension, this is an agreed-to extension? Because the tracking order is what it is. We'll get to that in a little bit.
It's been agreed to, Your Honor.
Okay.
And then, Your Honor, we're looking at depositions, but we don't want to consider noticing depositions yet until a lot of the document requests have been answered and the subpoenas for keeper of records. We haven't seen any of the records. We're aware of them certainly from the criminal trial, but there are a lot of records, as I understand it, that are still to be produced, so that we would then proceed with depositions as warranted in conjunction with counsel and obviously picking dates that work for all. But that's what we foresee in the immediate future, Your Honor.
They need more time.
Thank you. Let's hear from C.F. McCarthy, then.
Probably the same situation.
Your Honor, in a similar boat as to Waterfall, we were putting the finishing touches on our discovery responses. The last leg of it is just collecting communications from employees the night of the incident, some of whom no longer work for C.F. McCarthy's, but we anticipate having that included in the very short term and getting that over to my brothers.
Okay. All right, thank you. Let's hear from the plaintiffs then, in terms of the response to the procedural issue that was raised, in particular by Ms. Reed's counsel. Are you aware of the circumstances that they're seeking to join 10 additional defendants into this action?
Absolutely not, Your Honor.
It's the first notice you've gotten?
Of course, I would expect
not how the court system likes this stuff to work, folks.
Right, I would expect the courtesy of the meet and confer to at least let me know. Obviously, they can choose not to do so. That's their prerogative, but I certainly would have liked to have been made aware. Section 1983 actions, I believe, Your Honor, would have to go up through the federal court. We're not seeking to have this case removed in the federal court. We started in the state court. We're intending to move forward in the state court. We would like to have a state court, Plymouth jury decide this case. So to the extent that my brothers and sisters and all of those who are involved believe that they have other legal rights and they want to pursue other legal theories, that's their prerogative to do so. When it comes to interfering with our opportunity and right to justice, we're not looking to sideline that, Your Honor.
All right. Any response, counsel?
Thank you, Your Honor. We are asking for permission to serve a motion to advance this procedural proposal, so Mr. Diller is not being surprised by the argument that we're going to present to the court. He will have an opportunity to respond. There's no requirement that civil rights claims be brought in federal court. In fact, this court has jurisdiction over those claims. They all stem from the same facts, Your Honor. In the plaintiff's complaint, there are allegations that we need those parties to defend against. This is not just a wrongful death action. Our narrative of what took place.
But it is, though. It's the plaintiffs. Well, just hear me out for a second. When you say that it's not just a wrongful death, that's what the plaintiffs have alleged. The defendants have filed motions to dismiss portions of those. So this, at its essence, is a wrongful death action being brought by the plaintiffs, right? So what you're seeking to do is to be allowed to amend these proceedings and to effectively bring in 10 other defendants for the claims that the defendants have against those third parties that aren't noticed here, right? So you've got to procedurally give them notice as well as the plaintiffs notice of this event before it goes to any adjudication by the court.
And that's what we've built into this proposal, which is trying to streamline that process, not depriving them, the new parties, of the opportunity to argue both the procedure as well as the substance. And we're suggesting, instead of serving party X with a third party motion for a complaint, then that party opposes it, then the court rules, then that party perhaps is brought into the case, and then brings another motion to dismiss substantively. We're not seeking to...
Isn't that what the rule requires?
The rule does require that, but the court has discretion to consider the streamlined approach, and we'd like to brief that for Your Honor, but we're raising it at the status conference so that, because we are scheduling deadlines and events out into the future, we'd like to at least have the opportunity to advance that argument for the court and allow Mr. Diller to respond to it, and then we will act accordingly. That's the purpose of the disclosure of this today, Your Honor.
All right. So I don't know that there's any ruling by the court today that would have to be made relative to that, because it isn't even filed yet, so that there's nothing before the court. So ideally, what my instructions to the clerk's office by setting this event up was to get a trial date from you folks and then work backwards, like we would do with any wrongful death tort action, which this case is. I take exception to the defendant's notion that this is not just a tort action. It is. That's what it is. It's a civil case. I know there's a lot of people who are interested in this case, but at its heart, there are at this time eight parties involved in this case. Correct?
Yes,
there's 5 for the plaintiff, and there's 3 for the defendants, 2 corporations and Ms. Reed. So that's the way the case is shaping up. You've got your tracking order, so you understand what the deadlines are now. I have the tracking order, I think, basically shows this case as having discovery. Yeah, your discovery is supposed to close August of next year. Your Rule 56 motions to be done by October-ish of next year. Final pretrial conference February of 2027 with judgment by August 26th of 2027. So that's what the tracking order has in store as the case stands now, right? I mean, we could get you a trial date way sooner than that if you wanted to. I mean, literally, I could. The clerk and I were talking earlier before today's proceeding, and I may end up having to suspend, depending on what the circumstances. We were charging the jury on a homicide case earlier today, so we have a deliberating jury right now. So I don't know that I may have to suspend and then rejoin here in a little bit. But for now, so you understand it, we could get you a trial date as soon as practically this spring on this case. But to join 10 new defendants under wholly separate theories for people that haven't even been joined yet in this litigation puts that on its head. There's no way we could. You wouldn't even have this procedural process outlined by the spring, most likely.
I understand that, and that's the dilemma that we're trying to bring to the court's attention, because there is going to be an affirmative pursuit.
Well, you're saying an affirmative. You said earlier affirmative defense in this case, which those would not be affirmative defenses. Those are wholly separate third-party causes of action against people who are not part of this litigation, correct? So it's not an affirmative defense.
It's not an affirmative defense in the traditional sense, but it is part of the defense in the face of the wrongful death claims. The wrongful death claims stem from the same facts that the affirmative claims would be seeking to be pursued against. So it is the same set of facts. If we were to file a separate action, Your Honor, where Karen Reed is the plaintiff and these parties that I've identified are the defendants, we would be pursuing down 2 separate pieces of behemoth litigation when we can consolidate them at the same time. That's what we're trying to suggest may be a more streamlined approach. And it's not intended to delay. It's actually intended to try and synthesize the process and conserve resources, attain judicial economy without prejudicing the plaintiff. Discovery is already ongoing. But to have 2 depositions, for example, of parties in 2 separate cases, where we can have one and the claims could proceed at the same time, just seems to make judicial sense. That's why we're raising it. But we'd like to brief it if the court gives us that permission.
Okay. All right. On that last discrete issue, anything else from the plaintiffs?
We have served them with discovery, asking them, they have a burden if they're going to do affirmative defenses to establish that there are third parties who are responsible here. That can be their affirmative defense, but they have a burden to prove that. And if they can't meet that burden, then it should never come into our case. If they're seeking to overlap these 2 cases and throw it as far wide-ranging as they just announced, then there's no way that we would not be prejudiced by their strategy in the plaintiff's underlying case.
All right, those issues are reserved. I certainly am not going to make any ruling on that. There's nothing formally before the court, no written motion, no Rule 9A or 9C certificate, none of that stuff. So it's not procedurally before the court, but certainly I appreciate hearing the argument nonetheless that this may be the future landscape of the case.
That may have been a Hail Mary.
What also brings us here, when I noticed the status conference for today, the defendants have filed motions to dismiss. If you're prepared, I'll go forward on that, let you deal with the substance of the motions to dismiss. I have read through your material, so I get the gist of what the defendants are raising. Counsel, would you like to proceed?
Thank you, Your Honor. as we've briefed, Your Honor, the counts that are at issue in the motion to dismiss are counts 13, excuse me, the counts 10 through 13. They are infliction of emotional distress claims. As we have presented in our papers, none of the plaintiffs observed the alleged incident that is described in the complaint. None of the plaintiffs came upon the decedent in close enough proximity to state a claim for emotional distress. There is no, the cases, Your Honor, limit when a claimant can claim emotional distress. The cases talk about temporal, spatial, and relational limitations. Taking the claim that Kaylee Furbush has alleged, that claim is for negligence / reckless / intentional infliction of emotional distress. And the basis of that claim is that there was a discussion on the telephone or discussion after Karen Reed had left 34 Fairview in Canton and had somehow started to fabricate a story about what had taken place. Kaylee Furbush was not at the scene, and the perception of someone dying is not an actionable claim under any case that we can find in Massachusetts state law. So she wasn't at the scene, didn't come upon the decedent, and therefore doesn't have the same types of proof, at least is pled in the complaint, that would satisfy the limitations that the case law sets out, the temporal, the spatial, and the relational. With respect to the claims of emotional distress that have been brought by John O'Keefe's mother, father, and brother, again, they were not witnesses to the event. They came upon him many hours later. There are cases, and particularly the Cohen case that is cited in our brief, that speaks to the time that passes between an alleged event and when a family member or a bystander witnesses the consequences of that alleged event. And in that Cohen case, the court speaks to the fact that the mother of a young man that died in a plane crash didn't get to find out about it until many, many, many hours later, and the court denied the right to pursue an emotional distress claim. More importantly, Your Honor, there is a remedy here, if for the sake of argument, there is a remedy here through the wrongful death statute. And the wrongful death statute compensates for the types of harms that are alleged in the complaint. So what we're asking the court to do is to dismiss out the emotional distress claims because they are duplicative and allow the plaintiffs to pursue the wrongful death action singularly. We rest on our papers. Thank you, Judge.
All right, thank you. So let's turn to the other defendants if they want to be heard. You've filed separate motions essentially arguing the same relief, but if you have anything you want to add, you certainly can. The Waterfall?
Yes, Your Honor. On behalf of Waterfall, just very briefly, I think the distinction here the counsel's making is that these claims, these infliction of emotional distress claims, are intended when you're in the zone of danger or you're a recipient witness. And in this instance, it's many, many hours later that the parents are seeing the decedent in the hospital. I think it's after 7:50 a.m. And so based on what the Cohen case states and in terms of the principles that the courts have applied here, it just isn't, from a relational standpoint, close enough in proximity to be able to advance this type of claim. And in terms of the wrongful death statute, those loss of consortium damages, the damages of the loss of a son, if the plaintiff is making this claim going forward, are in fact addressed in that statute and obviously would be available as remedies to the plaintiff.
What about Semino versus Milford Keg Incorporated? I have a 1982 case that I found talking about the wrongful death, emotional distress injuries. Have you reviewed that case? I'll give this case site, 385 Mass 323. It's a 1982 case. It would seem to suggest that that emotional distress is really not preempted by the wrongful death statute?
Your Honor, I think the wrongful death statute alone would not necessarily cover all of the damages, but my argument would be more in line with the argument that in terms of where they are in relationship to the accident, since it wasn't witnessed, and since it wasn't immediately thereafter that they came upon the scene in a roadway, in a driveway, and observed the decedent, I would argue, Your Honor, based on that, that that's a problem for the plaintiff moving forward, and that that would be the court's consideration. I appreciate, Your Honor, that there are some differences in the wrongful death statute and emotional distress claims.
Okay, thank you. Ferreter versus Daniel O'Connell Sons, a case that goes back to 1980, also kind of speaks to that issue too. Let's hear from C.F. McCarthy's on that. Anything else to add on the motions to dismiss?
No, Your Honor.
No? Okay. All right, great. All right, I'll take that issue under advisement. I do have some, I'll read through your briefs a little more closely.
Allow us to.
Yeah, of course. What I was going to say is that what will happen in just a few moments, I'm going to give the plaintiff an opportunity to respond to that. But I want everyone who's sitting here to understand that the comments I'm making now are not really doing other than just trying to tease out what the issues are. Motions to dismiss are not based upon the evidence, but rather on the allegations that are contained in the complaint. And those allegations, for purposes of a motion to dismiss, have to be accepted as true. And the question is whether or not the plaintiffs have stated a plausible claim under the case law, Iacchino and others that deal with this issue. So with that context, plaintiff, if you want to respond to both the motions to dismiss raised by, I should say, both the two corporate defendants and Ms. Reed.
I do, Your Honor. Thank you. The question that's really posed for this court is, like you just said, assuming all facts are true, indulging every inference in the plaintiff's favor, does the plaintiff's complaint plausibly suggest that plaintiffs are entitled to relief? The answer is yes. This is a motion to dismiss, the lowest standard, the Brum case. Plaintiff's obstacle is a minimal hurdle, a relatively light burden, so long as the court looks at the allegations holistically. If relief to the plaintiff is plausible, by the cumulative effect of all the factual allegations pled, we survive the motion to dismiss standard and we move forward to discovery like we should in all cases and in this one. There are three arguments that my brothers have put forward in this case. We oppose all three of them as follows. Number one, the defendants incorrectly state the law by suggesting that NIED claims are subsumed or preempted by the wrongful death statute. Number two, Your Honor, the defendants improperly seek to limit the scope of NIED claims by creating an arbitrary bright-line test for such cases. Number three, Your Honor, the defendants failed to holistically consider the facts alleged and the known vulnerabilities of the plaintiffs when evaluating the defendant's extreme and outrageous conduct in violation of the infliction of emotional distress standard. I recognize that this court is not new to this case, and I recognize that most people already understand the facts, but I think it is important and significant that I at least highlight the ones that will be at issue here today. Throughout, we intend, like we did in the complaint, to refer to John O'Keefe as JJ. That is what he was affectionately referred to by his niece and nephew. JJ no longer has a voice. His life was wrongfully taken on January 29th, 2022. He lived a life of service. He was a Boston police officer, and his personal life, when JJ's older sister and brother-in-law tragically passed 2 months apart from each other, leaving 2 young children orphaned, JJ stepped up. He agreed to parent those children, to raise them as his own, and to support them. Fast forward to 2022, Your Honor. JJ is involved in a relationship with Miss Reed. It's been going on for a period of time at that time. January 29th, 2022, Karen drives drunk. She reverses her SUV. She knocks JJ down. She leaves him to die in the cold. and Reed knows that she strikes the plaintiff. Rather than seeking to help or calling 911, she returns to JJ's home. There, JJ's 14-year-old niece, Kaylee, a plaintiff in this case, is home alone, asleep. That's when Karen starts plotting. Now, it is significant for the facts for you to understand the context here. Karen Reed knows Kaylee well. She's been in her life for almost up to 2 years. She has served as a part-time maternal figure in her life. She knows that Kaylee is a vulnerable child, having lost 2 parents tragically. And 1 to 2 hours before JJ's body is ever found, before anybody knows his whereabouts, Karen Reed decides to wake up Kaylee in a panic. She tells Kaylee something happened to JJ. He's dead. He's been hit by a plow. Did I hit him? All to a 14-year-old child woken up from sleep who's already lost 2 parents. After provoking this chaos in the middle of the night, Miss Reed leaves Kaylee alone, vulnerable, shocked, and afraid. It's now 1 to 2 hours later. It's at or around 6 a.m. in the morning. JJ's injured body is now found. Right where Karen left him, buried in the snow, 911 is called. Now is when JJ's family learns of JJ's injury. JJ's injuries at this point enter into the O'Keefe's consciousness. At around 6 a.m., they rush to the hospital. It's 7:50 a.m. That's when the hospital pronounces JJ dead. And within minutes of being pronounced dead, that's when the O'Keefe family sees their son in the injured state that he was in as a result of the wrongful conduct. From January 29th forward, Your Honor, Karen Reed plots, she fabricates a conspiracy, she launches a public campaign of disinformation, and she involves a blogger named Turtle Boy. She leaks not for public information through him. She pits her followers against the O'Keefe family, and all the while, Karen knows that the O'Keefe family is also vulnerable, grieving another tragedy in their family. The O'Keefes and Kaylee suffer severe emotional distress. It's more than anguish and more than grief, and it is not overlapping with the wrongful death statute. So the first argument that the defendants made, they claim that JJ's parents are precluded from bringing NIED claims because such damages are duplicative of the wrongful death statute. We reject that argument. JJ's parents are the next of kin, and their emotional distress claims are not preempted by the wrongful death statute. They took their first shot across the bow by making that their primary argument. Presumptively, they did so because it believed it's their best argument. But the problem with that argument, as Your Honor has already pointed out, it patently misstates Massachusetts law. You have pointed out the Cimino case, where, let me just point out first the wrongful death statute. It has 2 components for damages. It has 2 buckets of damages. It has the estate's damages. Those all are JJ's damages. His conscious pain and suffering, the medical bills, things that relate to his damages. And then we have the second bucket, the next of kin bucket. Those are lost value damages. The lost value of JJ being in his next of kin's life. And in that case, Your Honor, it is just the parents. Now, they suggest that those are overlapping with the NIED, but Your Honor was right to point out the Cimino case, where a drunk driver kills a 9-year-old boy. The father of that 9-year-old boy brings a case against the drunk and the bar for over-serving him. The father brings 2 separate causes of action, one for wrongful death, one for NIED, negligent infliction of emotional distress. The court held in that, and I quote, argument that plaintiff's claim for emotional distress is preempted by wrongful death action misconstrues the common law cause of action for emotional distress. Emotional distress, as the concept has evolved in the Commonwealth, is a severe psychological shock directly resulting from experiencing or witnessing the effects of the defendant's conduct. A claim for damages based on emotional distress, the court says, does not include an administrator's claim for loss of consortium, which will be present in every wrongful death action such as this. Since emotional distress is a wrong to plaintiff distinct from what was done to his son and the statutory beneficiaries of the decedent, it is not a duplicative remedy. It is not preempted by the wrongful death statute, and that's page 334 of the Cimino case, Your Honor. Cimino still remains good law. You were right to point that out. It directly contradicts everything that my brothers just argued here in this court, and I see no reason why this court should overturn the good standing law that exists under the Cimino. We ask that Your Honor deny the motion to dismiss for that first argument. The second argument that they make, Your Honor, is that the plaintiff's NIED claims are not sufficiently contemporaneous with the alleged accident because the family sees JJ 7 hours after the accident. That the law does not endorse such a narrow, arbitrary interpretation of the law. It is misplaced for the defendants to focus arbitrarily on the time of the accident, because let's look at the law itself. The liability for NIED depends on a number of factors: where, when, and how the injury enters into the consciousness of the plaintiffs. And it also requires the degree of relationship between those plaintiffs. But I repeat, where, when, and how the injury enters into their consciousness. It is misplaced for the defendants to suggest that it matters that plaintiffs were not at the scene of the accident, because, as you pointed out, the Farrader case stands in the exact opposite, where the plaintiff who rushes onto the scene and finds his loved ones injured has no greater entitlement to emotional distress for that shock than a plaintiff who rushes to the hospital, so long as the shock follows closely on the heels of. It is misplaced for the defendants also to suggest that there is a bright line test for the number of hours that passes between the time of an accident and when the injury enters into the consciousness of the plaintiffs. Your Honor has persuasive authority from the Zachary case that shows that an NIED case can survive even when the close family doesn't see the deceased body or the injured body until a day later after the wrongdoing. There is no bright line test. NIED is a fact-intensive analysis. And when we apply the law to the facts of this case, let's look at where, when, and how the injury enters into the consciousness of the people that we're bringing those cases for. It's 12:30 a.m. and nobody except Karen Reed knows about JJ's injuries. Defendant's wrongdoing continues into those early hours. She knows she struck him. She seeks no medical help. Instead, she chooses to cover it up and hides the injuries from anyone. It's not until 6 a.m. that JJ's injuries are even capable of getting into anyone's consciousness. The O'Keefe family immediately learns of JJ's injury, and they, closely on the heels, they rush to the hospital, at which time they see the deceased body within minutes of him being declared dead. It is incredulous to think that a wrongdoer who hides the wrongdoing and the injury from anybody can be relieved of liability simply because the injury becomes knowable only after they disclose it. The defendant's cited cases are inapposite. They have no relationship to what is being asked of this court. They all involve a motion for summary judgment standard, which is a very different standard than the one that we are talking about here today, the motion to dismiss, the lowest hurdle to overcome. They try to equate it to a mother who learns of the rape of her daughter 7 months later, but that rape was known to other people within days. They try to relate it to the Migliore case, which has no relevance because it deals with somebody who has no close relationship. They didn't even know the decedent, and therefore it doesn't meet that standard. And then they rely on the Cohen case, which I heard both sides try to suggest has relevance. But in that case, Your Honor, the mother learns of her son's death 7 hours after the death. That's 7 hours after the injury occurred. And by the way, it was already knowable 7 hours earlier by other people when that plane crash was projected, and the son of the woman who brought the claim knew about her own, his brother's death. The mother is 1,000 miles away, so spatial proximity is not there, and she only learns of it via phone. Does not experience the injury and never sees the body. Contrast that with everything that we talked about, Your Honor, where as soon as it was knowable, they learned about it, they rushed to the hospital, they saw the body, and they saw the body within minutes of him being declared dead. The purpose of the law is to distinguish between emotional distress from perceiving an injury versus the expected anguish that any person would feel from the death of a loved one. I want to talk briefly about Kaylee and her NIED claim to suggest because she wasn't at the scene or because she was not at the hospital that day and they tried to spare her of that does not suggest she doesn't have a right. In fact, she experiences the trauma, the panic, the chaos of the injury contemporaneous with Karen Reed waking her up in the middle of the night and exclaiming that her parental figure, the third that she has now lost, was dead, hit by a plow or her SUV. Notably, this enters into her consciousness before anyone other than the wrongdoer knows of the injury. To the extent that defendant seeks relief because Kaylee did not see with her own 2 eyes, I refer you also to the Cohen case, which they cite for different reasons, but in it the language talks about sensory perceptions to suggest that you can't use other senses in order to perceive and experience the injury or the injurious event is wrong. Otherwise, no blind person would have a legal right under NIED. We have many senses. We use them all the time. And when it enters into our consciousness, it's hard to undo of it. It is very different from learning that your close family member has died. That is upsetting. It will be upsetting to anybody. But to have experienced the event or the injury and enters into your consciousness, that is the very reason and the foundation why NIED exists as a claim. So on that second, we also suggest that you should deny it because they experience the injuries closely on the heels of them being knowable and perceivable to anybody. Third, Your Honor, the defendants argue that the intentional/reckless infliction of emotional distress claim should fail because there's no extreme or outrageous conduct directed towards the plaintiff. But when viewed holistically, the facts demonstrate that Ms. Reed should have known her extreme and outrageous conduct would be detrimental to these vulnerable plaintiffs. And I use the word vulnerable plaintiffs because it's relevant to our case law, Your Honor. It's misplaced to suggest that the conduct needs to be directed immediately towards those plaintiffs. As long as she should have known that the emotional distress was the likely result of her conduct, that's sufficient under the reckless infliction of emotional distress standard. So how do we evaluate what is extreme and outrageous? It's fact intensive, but the law does recognize that some critically important factors that need to be considered when evaluating what is extreme and outrageous. Plaintiff's susceptibility, defendant's knowledge of that susceptibility, and the relationship between defendant and plaintiff. The case law all suggests that that gives rise to extreme and outrageous conduct. In evaluating whether defendant's conduct was extreme and outrageous, the courts should consider whether individuals at whom conduct is directed is known to be particularly susceptible to infliction of emotional distress. Boyle versus Wenck, 1979 case we cited to, Your Honor. Our case law has recognized susceptibilities to evaluate extreme and outrageous conduct to be a recent hospitalization in the Boyle case, a cancer patient in the Harrison case, elderly or frail people in the Bailey case, or children, minors, based on their age in the Sarkonis case, all that we've cited to, Your Honor, and I'm happy to give you cites. The law in Roman versus Trustees of Tufts College says, as it relates to this, the court should put as harsh a face on the defendant's actions as the basic facts would reasonably allow. The relationship of a plaintiff to the defendant and her knowledge of the plaintiff's sensitivities is an important consideration in determining whether the challenge conduct satisfies the extreme and outrageous conduct. That's the Russell case. Let's talk about Cayley as it relates to the infliction of emotional distress. Should defendant Karen Reed have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Those are the questions that ultimately we pose to a jury. Cayley was young, 14 years old. The defendant had a relationship with her, knew she was emotionally fragile, knew she was orphaned at the age of 6, knew that she lost both parents tragically. The defendant assumed this pseudo-parental role with Cayley for nearly up to 2 years. The defendant, Miss Reed, knows that she knocked JJ down. It's the middle of the night. She wakes up Cayley abruptly. She talks about JJ being dead, being struck by a plow, being struck by a vehicle. Mind you, this is all hours before anybody has even discovered his body, and she is now actively talking about him being dead. Then, after creating this chaotic, upsetting situation in this young, fragile girl's psyche, she leaves her. She leaves her home alone, shocked and frightened. Compound that by defendant's choice to speak her false narrative publicly, to use social media, to leak public information through Turtle Boy, to control that narrative. Why is Turtle Boy out there saying the O'Keefe's family period of grief has expired and they are now fair game? Who leaked the autopsy photos that got published by Turtle Boy for this vulnerable family to have to be exposed to that they weren't seen before? To the extent that the defendant argues that this is not extreme and outrageous, remember the law. It is the jury's role to decide whether the defendant's conduct was rude and clumsy or extreme and outrageous. That comes right from the case law. As it relates to the family, Your Honor, should the defendant, Karen Reed, have known that emotional distress was the likely result of her conduct? Was defendant's conduct extreme and outrageous? Again, those are the questions posed for a jury ultimately. But the law says conduct which the actor should have known would result in distress is actionable. And the plausibility standard, the motion to dismiss standard, which is where we're at right now, Your Honor, simply calls for enough facts to raise a reasonable expectation that discovery will reveal evidence of the illegal conduct. Margaret and John have now buried 2 children. Paul has buried all his siblings. Defendant always knew this. She has always known their vulnerability, and yet she creates a calculated and malicious campaign of disinformation designed to hide the truth in this case. She pits the O'Keefe family versus the Reed family, and a reporter who she asserts editorial control publicly proclaims to Reed supporters, the O'Keefe family's period of grief has expired and they are now fair game. Discovery will track how much leaked information defendant should have known would result in distress to the O'Keefe family. To the extent that the defendant suggests that this case sits nicely within any other case decided on this issue, remember the facts and circumstances here are exceptional. We wouldn't have these TV cameras or a full courthouse if they weren't exceptional. That is why we are here, Your Honor. It doesn't fit within a nice box like every one of those cases I cite. The Polay case where we talked about false police reports and harassment petitions were not considered towards emotional distress because they were petitioning activity. I want to talk about that briefly, because what Ms. Reed has done is not petitioning activity. It is not asserting a defense within a courthouse or having her legal counsel assert that defense or testifying at a court hearing. Instead, what Karen Reed is doing is not petitioning at all. She is waiving her Fifth Amendment privilege. She's speaking anywhere and everywhere that would give her a friendly audience with editorial control. She's gone on Dateline, Nightline, 2020, Fox 25, Boston Magazine, Vanity Fair, WEEI, Turtle Boy, HBO Max, ID Discovery, etc. There are more. This is an exceptional case that requires exceptional discovery, that requires us to decide this matter by a jury, not by a motion to dismiss phase, Your Honor. It is not like the Quinn case that they cite where there's an open adulterer involved, and so they think that's not extreme and outrageous. And it's not extreme and outrageous like it has nothing to do with the employment case where they fired somebody who had a criminal case pending, then they brought them back on, and he didn't like the way that they treated him after he was found not guilty, which is different, by the way, than innocent. The court should deny the third of those arguments. They should know that plaintiff's susceptibility and vulnerability are at issue in this case and are the very reason and foundation why it is extreme and outrageous conduct, and that defendants' improper actions would cause severe emotional distress. Defendants' actions were not rude and clumsy. They were extreme and outrageous. We ask Your Honor to allow this case to go forward with discovery, allow us to explore each and every one of those issues, because these are real damages for real people who have suffered long enough. Thank you.
All right, thank you. Any response from the defense?
Your Honor, briefly. Firstly, those allegations contained in the complaint are allegations which we will refute. Counsel cites to the Camino case, relies heavily on it. What counsel didn't tell the court is that in the Camino case, the father of the child who died in the car accident was himself hit. Part of the car accident. Gets up, runs to see his son. It's contemporaneous. It's at the time of the event. And the court didn't have the same spatial, relational, and temporal concerns that the cases speak to with respect to emotional distress claims. So I point that out for the Your Honor. He also mentioned much about conspiracy theories, much about going out in the public and creating a narrative, which is precisely the reason why we're going to brief the issue about why those other parties need to be in this case. As I'd said, it is more than just a wrongful death action, Your Honor. I respect the opportunity to brief that, and we rely on our papers and defer to the court on the motion to dismiss.
All right, thank you. Any other defendants wish to be heard on the issue? Anything else? All right, thank you. Certainly, there's a lot to the complaint, and again, for the record, so that people understand this, this is a pre-discovery form of relief that the defendants have sought by way of dismissing certain of the counts that are in this complaint, and the court has to consider the allegations as being truthful and every reasonable inference to be drawn in support of that. So I will look forward to reviewing that. I'll issue a decision as soon as I can. As expected, the lawyers in this case have advocated the positions of their clients very clearly, and I expect that with the procedural things that it might be asked for at some point, that this case will have a very long tail to it as it goes through the litigation process. We expect that in the court system, we give people their ability to try cases and get a jury to listen to the arguments and to ultimately make a decision. My experience in doing this for a very long time in different contexts is that that doesn't oftentimes bring the relief that people think it does, and so as a result, there's appellate processes. And so what I envision for the parties, unfortunately in this case, is a very long and sort of complex process that litigation provides. And you know, this is a civil case, it's not a criminal case. There are 8 parties as I identified, and those are the people that the court will be concerned with getting a fair trial at some point down the road. As I said, I could do this case, I could do this trial this spring if you'd like to. My sense is that there's nobody that's going to be ready to go to trial by the springtime. If you want me to assign a trial date, we could do so. I mean, literally, I've talked to the clerk, we could do it in March or April if you'd like to. But with the motions that are going to be pending, I suspect that that's not going to be the case, that you'll have to look at this from a more pragmatic point of view and decide when you're going to try to get this thing to a jury. You've got a lot of work to do between then and now. I'd like to still get a trial date for you. Now, I don't know what that's going to mean in terms of bringing in other parties. You know, I didn't expect, because the court has had no notice, that there'd be this interest in trying to move this complaint in the direction of other parties who aren't even named in this lawsuit, 10 additional parties, and there's relatively novel theories as I'm hearing it. But nonetheless, we'll let the parties file the motions that they need to, and we'll address them as each comes. But my point in raising this all is that the parties also have another way to do this case. They can do it by way of potential resolution. And I mean this sincerely when I say that being a judge for many years, you learn things. What you learn is that oftentimes litigation is an inartful way to try to resolve parties' disputes. There's alternative dispute resolution, there's mediation, there's all kinds of other avenues that we advance to try to get people what they want, which is resolution of a case. The most important thing, it would seem to me, to any party to this case, is to resolve the uncertainty, right? Uncertainty is what you don't get when you go through the litigation process. You go through and you hope for the best. Lawyers work really hard for their clients, and we expect them to do that. Ultimately, the court system can make sure that the trial is done, and it's done in a way that's fairest that we can make it, and ultimately a decision is made. Civil cases, though, are very unlike criminal cases, and that's usually not the end. Ask any of the lawyers here, clients can ask your lawyers about post-disposition or post-verdict process. It can be really long and arduous. I've had the pleasure of having trials that are 16, 18, 20 years old, and they're still going. Your clients don't have to do that. The clients can try to put some efforts, at least as much effort in the litigation process as trying to resolve it. Why do I say that? Because resolving cases resolves uncertainty, which is perhaps the most important thing any client can get in a case. I say that because you'll have that opportunity through all the process. You've heard me outline it. Your discovery isn't even closing until the discovery is going to close next December, but it's really 2027 that you're looking for a trial in this case realistically. Again, we could do it in 2026 in the spring if you want to. And I'm going to ask the parties to work collaboratively to try to come up with a trial date that is workable. I understand that's a wrench has been thrown into the works because of this other process. We'll probably have to deal with that in the short term. I'll pledge to try to get you what you can as quickly as I can. I tend to get decisions out pretty quickly. I tend to try to move things to get parties what they want, which is ultimately their day in court. I'm just telling you at the outset that I think that it's worthy of exploring possible resolutions on your own. You can do it through this court. We have a mediation process that you can avail yourselves of, judicial settlement conferences. You can go through private neutrals, because there are now 8 parties involved in this case, 2 of which are corporate defendants, 1 of which is Ms. Reed. And so that's going to give you a lot of opportunity for dialogue. My sense is I'm probably wasting my time by doing it at this stage of the process, but I think it's important that your clients know that there is an alternative way out of this. Money damages are all the plaintiff can ask for. Nobody can restore, we say this when people lose loved ones or that they have some meaningful part of their body or mind that's been lost in a litigation. We can't restore that. We award money damages. And so ultimately that's what the imperfect litigation system will have. Knowing that, there's a huge opportunity to try to resolve a case like this, and I would urge the parties to have very frank discussions with their lawyers about that, and ask yourselves, is it worth going forward with all the uncertainty? And I'm not going to explore with your clients what everybody has to lose. Everyone knows that. If I were representing a plaintiff in this case, I would tell them all about things like the time it takes to get to litigation, what we have the burden of proof. Yes, it's easier with a burden of proof that's by a more likely than not standard versus a proof beyond a reasonable doubt, but still it's a burden of proof nonetheless. But there's a time value of money. People don't, getting this behind them is an important issue. From the defendant's point of view, again, time is money. There's a lot of time, effort, and anxiety that is put together with a litigation like this. We have 2 ongoing, as far as I understand, the 2 businesses in Canton are ongoing, and they have their business decisions they have to make ultimately. They're defendants in this case. They have to understand the risk of going forward in a trial versus resolution. Of course, Ms. Reed herself, a lifetime of potentially facing the uncertainty of a judgment and what that will mean in terms of ability to put this matter behind and going forward. It's going to be very complex. So you can resolve that by looking at putting some effort into this case to resolve it. If you can, great. If not, we stand here committed to giving you the next opportunity to get it before a jury, which I'm suggesting to you could do as soon as this spring, if you want to. Okay. Anything else we need to address this afternoon?
Wow. What a day.
Not from the defendant, Your Honor.
Okay, great. I'll issue a decision on the motion to dismiss. Tracking order stays in place as it is now, but here's my concern, folks. With this motion that the defense team is talking about putting together, I think that needs to be looked at sooner rather than later. It's a big deal.
Huge.
Right?
Yes, Your Honor.
Okay. Why don't we get a status date? When do you want to? And we can do by Zoom, folks, if it's just as easy. My order was to have everybody here so that you all get a chance to meet. I want people to be understanding that this is a civil matter, and I want you to be, at least to some extent, trying to be civil about how to resolve your issues. I would have liked to have seen, for instance, this motion that was brought about in open court should have really been discussed ahead of time so you have a better position on it, but I don't want to waste your time. You want to do the next hearing by Zoom? You want to do it in person? You tell me. Plaintiff?
We're agnostic, Your Honor. I'll do what...
We're agnostic? Is that what you said?
Yeah, as it relates to that. We'll come in person or we'll do it via Zoom.
Defense?
Your Honor, we prefer to be in person.
Okay.
Either way, Your Honor.
Okay. All right, we'll do it in person. Fine, we'll do it down here in Plymouth. I will be moving into the Brockton court next month, but this is especially assigned, at least for now, so I'll come back down here. That's not a problem. Mr. Clerk, do you want to suggest a date for us?
Sure. How many days out do you want to go? 60 days, 90 days?
Yeah, probably 60 days.
50 days? November...
Yeah, this is 10.
21st, Friday in the end of November.
November 21st is the next date.
Yeah, that November 21st.
You'll have a decision before
I'll
then.
have a decision out before then, certainly, as quickly as I can. 11/21, and that would be for a status regarding tracking order and discovery, and any motions, Rule 15 motions to amend or bring in third parties.
Wow.
Okay. All right. Thank you, folks. We'll see you then.
Thank you, Your Honor. Have a nice day.
All right.
All right, so this was the big meet and greet, the first big shebang.
I don't think so.
Nothing with the jury?
Judge asked about the jury, if they reached a verdict yet. He's got another case that's in jury deliberations right now. I'm not sure what that one is. But yeah, we're gonna bail on this just a little bit. Let me see if I can explain this to you a little bit. I actually had it going in 2 ears at different times. One with Zoom, straight from the court, and one for the pool feed. Wow. The fireworks in this one, as this was the first discovery thing, is basically saying, hey, we're just getting started. He says, because we're just beginning, the judge says, I want all of you guys here so you can like look at each other and be like, oh, hey, nice to see you. I'm on the plaintiffs. I'm on the defense. I'm with McCarthy's, and all that. We want to meet everybody. And so they're here in person. This is a wrongful death suit where Karen and the 2 bars are being sued. And there are 5 people suing, like there are 5 people claiming damages. We did hear the lawyer for those who are suing, for the plaintiff, saying a lot of things that sounded like facts, right? Karen did this, she did this, and she knew this, and she... lawyers can't be sued for what they say in court. They're protected, right? And they're presenting this story as if it's our side is right, and that's just what they do. So all these matters would be disputed and fought over in this new setting. But instead of Karen Reed's freedom on the line, it's Karen Reed's money and the bar's money, or most likely the insurance company's money. That is at play here. That's it. That's the only thing that can happen is money can exchange hands. As it starts out, Karen Reed's defense team fired a shot across the bow and said, Judge, we're countersuing, and we're also including these other parties. We're including some people who aren't listed on here, and we want the discovery from all that as well. And that is like, whoa. And it was a surprise. It was a huge surprise, and it would change everything about this case. It would just go absolutely nuts. But what's the monetary amount? They haven't even started to talk about the money, how much it would be. But it's in the millions and millions. When you have a wrongful death, negligent infliction of emotional distress or intentional infliction of emotional distress, the worst one, and a life lost, it's millions. This is a different case. A lot of you are saying in here, how in the world can they do that when it was already proven? The jury said she was not guilty. The jury came back and said not guilty. How can they do this? Different case. That was a criminal case. She's not guilty criminally. The trial to determine if she is liable civilly is not even connected to the two. I think it would be helpful in the civil suit if she was convicted in the criminal case, but because she was not convicted in the criminal case does not mean that she can't be found liable in the civil case. Those things can happen, like we saw with OJ. Interesting case. It's just barely getting started, and everyone's like, so what's going to happen next? Well, we're going to wait. We're going to wait for 60 days where they're still turning over information. That we're just at the very, very beginning. The judge said likely this trial wouldn't be till 2027. Most likely 2027. Let's give it a couple years. Okay, it's going to take some time to develop. Imagine if this were a criminal case, this might be akin to, say, like the arraignment of a murder suspect when he first gets arrested and put in jail. And then you've got all the processes on a lot of appearances that go into setting up the actual trial, which could be a couple of years down the road. So that's what it is. That's where we're at. Any other questions? I don't know who they would call. I honestly don't. I don't know how they're going to argue this, if they're going to, AJ get up and say there was no collision, there was no collision, there was no collision. I don't know how they would do it. It'd probably be a little bit different than the criminal case, because that burden is lower, much lower. It might be very easy for the O'Keefes to prove some facts that they were not able to prove, at least to the jury's contentment, in the criminal charge. So, sounds like fruit from the poisonous tree. Lots and lots of money, lots of lawyers. If they bring in, for instance, if the judge says yes, because this countersuit and the claims you're making, but you're honestly, Karen Reed's lawyers are saying, we need this to be wrapped into one big case with our suit, them suing us and us suing this other party who's not currently involved in the case. We need that to happen because it's the same set of facts that bring it about, and we can't defend Karen from the first suit without the inclusion of the second. That's an interesting argument. It's a very interesting argument. I honestly think this is sort of throwing everything, just trying everything and seeing if they can win. Obviously, if you can gain some ground, a little bit of ground at the very beginning, it could have huge impact later on to the trajectory of the trial. So this is really cool. I can't wait to hear what the judge rules on this. I think he's inclined to not allow it, which I think that Karen's team is fully aware of. It doesn't mean that Karen can't sue them. It would mean that if she does sue them, it would be a separate trial. And it might be more difficult for her to bring information from that separate trial into this trial. So, wild. The bars can settle separately. Karen might settle and the bars not, or the bars settle and Karen doesn't. I do think that the two families, Karen Reed and the O'Keefes, there's not a lot of seeing eye to eye that's happening between them. So it seems unreasonable. You heard the judge explain, you can resolve these cases. It's a lot quicker. Oftentimes, it's worth it. It's a more certain outcome. It happens faster. There's less dragging through the court system. Talk to your customers and tell them that there's this option. And he was talking to both sides, but I don't think it's going to happen. She's countersuing the Alberts, the McCabe's, and Higgins. I thought Proctor was on the list too, right? Got a phone call if I can find my cord. Hang on 1 second.
Call from Angela.
Angela, how are you doing?
I'm doing good. You?
I'm doing great. What'd you think of that?
Great. Wow.
It was spicy.
I managed to be in the worst possible place when they announced 1983 suits coming. I mean, I was out in the public, surrounded by people. Seriously, people, I need to stop watching trials while on the go, You
need to just sit at home and watch trials all day long. Get a job that allows you to do that. That's what I did.
Yeah. I mean, I was on my way home from work, okay? So, but yeah, I mean, I was so happy that they said, I mean, they didn't explicitly say that 1983 is coming, but, I mean, come on. You don't have to be a genius to, that it is coming. That they confirmed that.
So, I'm going to show my ignorance here. We're talking about the book, 1983, right?
Yeah. 1983 book called Lawsuit.
Yeah.
Yeah. There's something that bugged me when they announced, and it's still bugging me, when they announced, and it's funny that you said ignorance just now. When they announced who they want to bring into the lawsuit, and that who are they going to sue, and then plaintiffs going, "Oh my God, we didn't know it." Not in those words, but translation that meant is what they meant. It's basically what their defense was, what Karen Reed's defense was in the criminal trial. How are you so ignorant?
Let me back up just a little bit. 1983, that's the ability for her to sue governments, right? to sue government officials, police departments, town people. Yeah, all those. That's going to be. Okay, I thought for some reason I was thinking 1984. I'm like, was that a reference to like how the the rise of the little man, we're going to get you type thing? But no, I hear you. 1983.
For some reason, I thought
42 U.S. Code 1983.
Yeah. For some reason in the beginning I thought it was 1989 lawsuit, but thankfully I was corrected in time. So yeah. But I mean, how ignorant? I mean, seriously, have you watched even the first and second trial? It was their defense. I mean, even the Birds knew that they are going to bring into the lawsuit McAlberts and everybody else.
Yeah.
And they played ignorant. Seriously, how dumb, how not so nice are you?
Yeah, I'm sure they could have guessed this was happening. If they didn't, they had a pretty good defense sort of ready. I think they knew. They're just playing like they didn't know. But
yeah,
I don't know.
Okay, can I for once be like neutral party? Like
that's up to you. Can you be neutral? No, just kidding. Go for it.
Yeah, I can, because I am actually playing for this one. I might actually, both sides may agree with me on this one. Depends on, but when they said they want to bring in, like, they want to use, like, they want to put together, merge the two cases, like the ones that is right now and the one that Karen Reed is bringing, so they can use the evidence from that case in the first case. That brought me something, like someone said somewhere, is it possible, lawyers, please answer me on this question, because I'm not a lawyer, and I don't think Google will help me in answering this question, but let's say that O'Keefe's realize that the truth and that Karen Reed did not do it, and that someone else did it. Can they join Karen in suing? Like, is there a way? Is this merging lawsuit a way that Karen, like, leaving the space for O'Keefe's to join her in suing the McAlbert and etc.?
I don't think they would, and I think that it presents problems legally, because it gets to the point where every action in court is so convoluted because of the different players and the different, who's suing what and who is what. It just becomes so cumbersome to process that I think the court, even though it's a duplication of efforts, it's definitely a higher expense to have separate trials. I think they're going to say these need to be separate. We can't put these together. Look how crazy the case in Fulton County with all those defendants were, the RICO case with every single lawyer. Imagine that, but having like little three directions of suing each other going on amongst the different parties, and some are involved in this suit, but only these two are involved in that one, and who gets to argue this and not that, and it's a nightmare for the judge. I mean, it's like he needs a lot of Excedrin to handle that every single day. I don't think they would wrap that in, and I don't think they will wrap this in either.
It is funny that you mentioned RICO, because there is, I may have mentioned something, and once, that I like to write crime fiction, and people who are on Discord know that because I already said this on Discord, and I have I researched the RICO statute and everything that needs to be included to be indicted, not just to be convicted of RICO is a whole other case, but to be indicted of RICO, and then etc.
Yeah.
So that took me down a rabbit hole of everything that needs to be into the what prosecution has to prove it. And again, this is for my book research. That was initially thought. That's why I researched it. And then as I researched it, that got me thinking of Karen Reed case and FBI. And that got me thinking, like, is FBI doing making a RICO case or something? They are quiet, and they're suspiciously quiet, you know. Farwell has not had a single hearing since he was arrested. Word on the street, he is cooperating. So what is this FBI doing? Like, is Karen Reed too small of a case, like too small of a fish? They want to go after something or someone bigger?
I don't think there's anything for them to take action on. I think there's individuals that are either dirty or corrupt, but I don't think it's the scope or the form that would rise to that standard.
That's what I thought initially, but then I started going down the rabbit hole of RICO and statute because they can go after someone individually for RICO. There is statute for someone where they can go.
I don't think they would.
That's why I thought.
I don't think they would in this one. Yeah.
Yeah.
That's just my call.
Well, we'll see.
Anyway.
Time will only tell.
So we started with a slow day and then ended with a spicy one. That's
I was at work. For me, it was like I was at like one of the busiest parts of the hospital, which, interestingly enough, is not ER at my hospital. So my whole day was busy. So yeah.
Well, Angela, good to hear your voice. It's been a while since we've talked. Appreciate it. Hope you continue to do well. Listen to you again soon.
And sorry for talking about so many points
no, you're
on
good.
this call.
All right. We'll see you.
See you. Bye-bye.
Bye. All right. Ivan, I texted you back, man. I texted you back just a couple hours later. You didn't respond. We need a little disagreement in the chat. We've got a little. Please tell us Josh has a funny for us to end today on something. Josh might be busy, like out fishing or something. Let's see. He might have one. Possibly. He does. Here we go. Oh, this is a trial starting tomorrow. Chandler Court pleas and JTR. Thurston 4, Josh says. Let's take a peek at Thurston. I think this is it, right? Okay. So if I go there right now, what's happening up in Thurston right now? Do we have to back up on this one? Oh, he looks familiar. The prosecutor looks familiar. Josh, do we need to back up at all? There's a trial starting tomorrow. What'd you say? 1 hour, 27-minute motion in limine. This is the 1 hour, 27 motion. 1 hour, 27 minutes. That ended right about here. Okay. Well, let's find the beginning here, see what this is. This is a trial that starts tomorrow. We might jump to this.
Morning, it's Thurston County District Court trial calendar for Monday, the 22nd of September. We have folks in the courtroom, others appearing remote. These proceedings are being live streamed on YouTube to increase public access. Again. Mr. Holcomb, good morning.
Good morning, Your Honor.
Weston, good morning.
Morning.
Okay, from the state standpoint, two of you arm wrestle. Can you tell me who's going to be the trial that goes today?
Oh, I want to watch this.
It's ultimately up to the discretion of the court, Your Honor, but my understanding is that Mr. Weston's case is less speedy trial time left on it.
If I could step out real quick, Your Honor. My deputy just called me real quick.
Well, that's when we would decide it.
Wow.
I'll just say we don't have a rule on here that you don't mention other creators. It is polite to not go on a stream and say, hey, everyone, go over to this other creator. Guess what they're doing right now? That's just common courtesy, but we don't have a rule about that. We do ask that you be respectful of other creators. If you agree with them, don't agree with them.
Mr. Weston's out. Mr. Holcomb state's ready to go on the Woods matter.
And
yes, Your Honor.
Generally, we try to
Ms.
ask you
Moore,
to stay
you ready to
on
go on the
topic.
Woods matter?
We ask you to stay on topic. So sometimes, there might be times we're talking about Ian or Rob or, Kurt might come on. We talk about things like that. We just ask everyone to be just respectful wherever they are. So, Swanee, I saw your comment. Tracy Rocks, does it make sense now? It's 42 U.S. Code Section 1983 is a federal law that allows individuals to sue state and local government officials who violate their federal
Weston.
constitutional rights.
Yes, Your Honor.
While acting under the color of law.
Are you ready to go on the Smith matter? Smith matters.
That doesn't
It might be Mr. Holcomb's case, Your Honor.
That's mine, Your Honor.
Okay, so, and which matter, Mr. Weston, are you here for?
The Johnson matter, Bonnie Johnson.
Okay. That's obviously not going since there was an affidavit filed and I'm the trial judge today. So
My understanding was, based on what Judge Woodcox told me, is you guys would swap around if needed.
Nope.
Okay.
Not happening.
Okay.
This is
okay. So it comes
DUI
down
and obstruction
to
of
Smith
justice.
and Woods. Am I right? Is there
Obstruction
anything
of
else?
police officer.
I believe that's it, Your Honor.
Okay. So, Mr. Holcomb, which is your preference?
My preference would be the Woods matter, Your Honor. It's a Tox DUI from back in 2023. It also involves an obstruction charge. The other case is a driving while license suspended third. And I could be wrong, but I don't believe the defendant is present for that as of yet.
Ms. Moore, good morning again.
Good morning.
And are we expecting Mr. Smith today?
I was, Your Honor. I have not seen him yet either.
Oh, missing a client?
All right.
Rebecca
The
just finished.
Smith matters have been somewhat problematic.
Just ended.
Why they keep getting continued, just to have another charge filed, continued and get another charge, and continued and get another charge. We're paying the price of that. We have, 6 cases backed up, which is kind of a ridiculous situation. So, frankly, just as a heads up to counsel, I think I'm going to recommend to my colleagues that we go back to the old process on a driving suspended third. At pretrial, you either firmly set a trial and it's going to be a trial. You get one pretrial, and if you want to resolve the matter, you plead on that day, and then we can set off sentencing if the goal is to try to get a reduced recommendation if somebody shows up with a license. That used to be the process in district court. Rather than, we've had ridiculous number of hearings from Mr. Smith. So, and they end up hurting us in this way. So today, for example.
What about Mr. Farag?
We have 2 cases where I showed speedy trial expiring on Thursday, and the state's making a choice to go to trial on Woods, which tells me at least one of Mr. Smith's cases is going to be dismissed for speedy trial violation.
Wow. Yay. Love those.
And that's the situation we find ourselves in. So, any comment from the state?
My understanding, Your Honor, is firstly, if the defendant fails to appear.
Right. Yeah, I'm just assuming he's going to show up. If he doesn't, then we have a different issue.
Secondly, if the defendant does appear, my understanding is that the court does have the discretion to, on its own volition or the motion of the parties, continue it for the purpose of the administration of justice, so long as it does not in any way prejudice the defendant's ability to present a case. There's no such prejudice in this case, and given the amount of cases that are on for today and the situation the court has described, this seems to me like a situation where a continuance for the administration of justice would make sense.
we'd have to continue it until 2026 almost with the number of cases he has set. So I'm going to force you to make a choice between case ending in 7090 and case ending in 8993. Which one do you prefer not to have dismissed for speedy trial violation, since they both have the same expiration date? And you can hold that thought. You don't have to do it right now, because obviously if he doesn't show up, that's a different matter. And so I'm not going to make it
get to court
ruling
when
right
dismissed.
Now, since he's not here. But think
Somebody
about
get
that.
Mr. Smith.
I'm going to dismiss one of those two cases if he appears.
Understood.
Okay. All right. And I'll call our cases where we're going to take pleas here in just a moment. So looks like the Woods matter is the one that's going today, and you have all your witnesses, Mr.
Yes,
Holcomb? Okay. And Ms. Moore, you're ready to go in that matter?
I am, Your Honor.
And look like you don't have any additional witnesses other than potentially Mr. Woods. Is that correct? Okay. All right. You can step back and I'll take the pleas, unless you have a plea.
Sure. And Your Honor, are we going to reset dates for that Johnson matter, or are we doing that later?
That's your only matter?
Well, I mean, I guess I'm handling this courtroom too now.
Well, yeah,
we can redo it. We can do it after all the pleas and everything. I just wanted to ensure that that was actually happening.
Yeah. I'm not going to ignore the Johnson matter. It's just I'm the trial judge today. There's an affidavit. I can't hear it. So, all right. And Mr. Sachevsky, you look like you were ready to go.
We're going to skip these pleas. How far do I have to skip, Josh? Do you have a timestamp?
Yes. All right.
Start at the 1 hour, 27-minute motion in limine. First of many, so we skip all the way to 127. You told me that earlier. We got the background here. Let's see if Mr. Smith showed up.
Mr. Holcomb states proceeding on one count of DUI.
Two counts, Your Honor. One count of
There
DUI and one count of obstructing law enforcement.
Okay, thank you.
So DUI and obstruction of law, obstructing law enforcement. So the other one gets dismissed for speedy trial violation, which I believe is dismissed with prejudice.
They are.
Correct me if I'm wrong on
the sole reason for that is one is a traffic offense and one is a non-traffic offense. So for whatever reason, DOL is requiring us to do that. But,
and I'm assuming, Ms. Moore, you understood you were going to trial on both matters?
I did, Your Honor.
Okay. So, Amy, the case ending in 191 is going to trial today with the case ending in 190. And this is from 2023, is that right?
correct, Your Honor. November 30th of 2023.
Okay.
Is that a religious head covering, or is it just like a bandana that he's wearing? I can't see on my screen. My eyes are bad.
Mr. Holcomb names the state witnesses, please.
Your Honor, the state anticipates calling Washington State Patrol Trooper Jonathan Murray, Washington State Patrol Trooper Claudia M. Travis, and Washington State Toxicologist and Forensic Scientist Alec McDougall.
Okay, 3 witnesses.
Okay, I got Trooper Murray, Trooper Travis. What's her first name?
Claudia. It's Claudia.
And our state tox is
Alec McDougall.
ALEC.
Yes, ALEC. Last name is McDougall.
Thank you.
McDougall.
And Ms. Moore, I believe you indicated no other witnesses. Is that right?
That is correct, Your Honor. We reserve the right to call Mr. Woods as a witness, but otherwise.
Of course. Okay.
This Mr. Woods, Mr. Smith, is the one who needed to show up just to get a case dismissed.
I'll impose the normal time limits for counsel in this case, 15 minutes on voir dire, 10 on opening, 15 on closing. Mr. Holcomb, any objection from the state?
None presently at this time, Your Honor. As the trial goes on, I may request like an additional 5 minutes at the end, but I'm not asking for that at this time.
Thank you. And how much would you like to reserve on your closing argument?
2 minutes.
Okay.
2 minute closing for brother.
And Ms. Moore, any objection to those time limits?
No, Your Honor.
Okay, thank you.
They're about to call a jury. They're about to seat a jury, so they'll do that a little later today. They're just laying the groundwork for the whole trial, which will begin today and ends tomorrow.
I read Mr. Holcomb's motions in limine. My memory serves, they were standard motions in limine, none really case specific.
But Ms. Moore wants to argue something.
I would agree they were mostly standard, Your Honor. I do have objections to a couple of them.
Okay, actually, now I see that. Okay, I did read Ms. Moore's as well.
Can we hear the argument?
And they seem to be the standard as well.
I also do have some objections or clarification requests on a few of Ms. Moore's.
Okay, we'll just see here.
Warrior Queen, the bonus. Everyone who shows up gets a free vacation.
Mm-hmm.
Amy, would you go to the latest fish file and print up the motions in limine submitted both by the state and by the defense? Give me hard copies of those, please.
And he's going to go grab some hard copies for the judge to mark up and print on. So, Josh, jury selection tonight is at 5 p.m. Eastern. You guys want a late night tonight watching jury selection here in Holiday Inn Court? It was like, yes, yes, I want some. That'll give us jury selection and openings tonight. Jury selection is probably going to take at least an hour. Openings probably another half hour. So we could be here till about 6:30 or 7, roughly. I'll have to make a few calls. I literally this morning I was on the phone hiring someone to help me on the on my gig this weekend, and I was successful. Got a guy who's familiar with what I do. Jamie Jane, where did that time go? My gosh, not a big chatter, but always here. Jamie Jane with the Pink Courthouse and 29 months of support. Oh, gee, that is awesome. Thank you so much, Jamie Jane. Glad you lurk. So this court is on West Coast. So they're several hours back. We're on East Coast, so it starts at 5 Eastern for jury selection. They're still going to make this. We still want to hear what this motion in limine is. Either we do late night or do all tomorrow. Your call. I'm worried that, well, I could record it tonight and save it for us for tomorrow. That's probably better. Josh, let me record it tonight because they're not going to be up and ready to work until lunchtime, right? Because they take so long to get up in the morning, possibly because it's early in the morning over there. But we'll probably record it. We'll finish this motion in limine. We'll record the jury selection and opening statements, and we'll get that first thing in the morning to get us ready for court, which begins tomorrow. Sorry, AWOL. I do apologize. I know you've been working all day. Grandma of 6, that is awesome. For those who are hitting their membership milestones, if you look on the chat window, at the bottom of chat, there's a little, I guess what looks like a dollar bill symbol, an icon. You can click on that, and if you have a membership message that's available, and you get one per month, it'll tell you have a free membership milestone message, and you can send a message that way. And it shows up like this one for Gene Daughtry, who says, say it again. OG, 31 months. Thank you, Gene. That is awesome. 31. Say it again. When I'm at Waffle House tomorrow for my birthday breakfast, can I call you so you can tell them about my free waffle? Text me real quick, Legally Blonde. Text me. I'll get you squared away. I'll send you your RA exclusive Waffle House coupon. Bev Wolf, a member for 19 months. Woohoo! That's awesome. Bev, I think officially at 20 months you're an OG, but I'll say it anyway. OG! Because I think you joined us for a while before you became a member. Let's see. And yes, you are on the form, Legally Blonde. You've done it all appropriately. That's awesome. We're going to sing to you tomorrow. 80s Music Man, RA pouring the salt on my gray name. Can't send my member chat, milestone chat. 80s Music Man, just put on the hoodie I sent you as a consolation prize. And just, that you just have to just suck it up. I'm sorry. I don't know what else we could do. We've done everything. I've talked to YouTube specifically about your case. I'm trying to get this fixed, and it just won't work. Kate Tastrophe, member for 12 months, been lurking since Daryl Brooks. That makes you an OG. That's awesome. You know what, right now? I'm at my 3-year mark since we became monetized.
I would object to this motion. The point of voir dire is to root out juror bias. The state is asking that the defense not ask any questions which misstate which I guess I would say the state is saying which misstate the burden of proof. From defense perspective, it's not misstating the burden of proof. It's questions that contain a misstatement for the purposes of rooting out whether a juror misunderstands the burden of proof. A potential juror who believes they would need defense to prove a defendant's innocence in order to find them not guilty and cannot overcome that belief no matter what would need to be stricken for cause. And in that situation, that's something I think the court and both counsel need to know.
Okay, when I'm saying that is for both of you, if you hear a question that you believe is going in that direction, you're going to have to make a request to me regarding that. So I'll reserve and wait to hear what a question may be.
Understood.
I think you both understand what can be asked and what can't be asked. Okay.
Allison, the pink courthouse looks great.
And then for more of a clarification on state's motion in limine number 15. Obviously defense, I obviously understand, ER 801, basic rule of evidence, a statement of Mr. Woods is not hearsay, but can be admitted only as a statement of a party opponent. My understanding, though, would be that once such a statement has been admitted under the party opponent rule on direct, it's possible defense would need to reference it on cross-examination of the state's witness, as it may be necessary to lay foundation for questions on cross. So it says reference, but
right. I would agree with you.
Okay.
Just to clarify, Your Honor, part of the intention and part of the intention behind number 15 is that I've been in trials in the past where defense has asked law enforcement something that the defendant said that was not elicited by the state, and the defense counsel at that time was under the impression that it was admissible through an opposing party because the officer was an opposing party referencing something that he heard the defendant say. So that's more in a reference to that. Obviously, if the state asks for law enforcement to say something that the defendant said, defense is more than welcome to ask the officer to clarify that or to talk about the context of it.
Debbie
And then point of
Wilson,
clarification is
22 or
defense would have
24
no
months.
objection if the wording was introduced.
gee.
It's just where it says reference is
Right.
my concern.
Okay.
Texas Mom, my favorite place to hang out. Thank you, Texas Mom.
I think
17
that's
months. Or
excellent
excuse me,
editorial
15 months.
suggestion, and I'll actually write that in. So, Mr. Holcomb, if you believe Ms. Moore has done something by way of bringing that to the juror's attention, a statement that had not previously been
Newbie.
introduced, then you can make the objection.
Thank you, Your Honor.
Okay,
3
I
months,
will,
that's awesome.
I read your instruction or your objection number 16. I'll deny that. I will do what I've done for 25 years and allow juror questions.
Understood, Your Honor.
Okay.
He tried to
And
not let
Ms.
them
Moore, did
ask
you have
juror
anything else
questions.
on state's objection, state's motion?
In Vordier.
No, Your Honor.
Okay. And Mr. Holcomb on Ms. Moore.
Yes, Your Honor. First, going to number 11. I'll just take these in chronological order, so I don't have any objections to any of the motions in limine prior to number 11.
Yeah, and so I checked. There's very limited criminal history here. Actually, nothing other than these charges. So I don't see any.
There's some out-of-state charges, but I don't plan to reference them.
Okay. All right.
Laura,
Okay,
77.
So number 11 talks about any testimony regarding alcohol absorption and burn-off rates and related calculations, and then it goes on to talk about WID marks. The state has no intention of using WID marks in this case. The state doesn't currently have any intention of using retrograde extrapolation in this case. What the state does intend to do is ask of Mr. Alec McDougall, who is a trained forensic scientist and toxicologist with Washington State Patrol, and the state will lay that foundation before asking these questions. But the state does intend to ask about the effect of alcohol on the human body, how that can manifest in physical signs. The state also intends to ask about whether alcohol increases or decreases with time, because there is a fair amount of gap in time between the initial encounter with law enforcement and the time that the blood draw was initiated. So that's the objection to number 11, is it says preclude any testimony regarding alcohol absorption and burn-off rates. So it's just too broad and would preclude the state from asking those appropriate questions.
Thank you. Ms. Moore. Well, I'll make it easy for you. If you hear a question that you think calls for something inappropriate, I'm going to reserve ruling on that. You'll have to make the objection at the time.
Understood. Thank you.
Mr. Hall.
Next, Your Honor, is number 12. This again, the state will ask about the troopers' training and experience and education that is relevant to standard field sobriety tests as well as DUIs in general. So then the state will ask if, hey, are these standard field sobriety tests used throughout the state? And we'll lay the foundation for the credibility through those means. But the state does not believe that we're required to bring in an independent expert to talk about the scientific veracity of standard field sobriety tests in an alcohol context. Right. It's a well understood and accepted practice within the state.
And Ms. Moore, your view is different on that?
It is, Your Honor.
Okay. On this one, I'm going to agree with Mr. Holcomb.
Okay.
I will allow testimony regarding field sobriety tests as long as the officer can indicate they performed as he was trained. Mr. Holcomb?
Number 15, again, really the problem with number 15 is that it's too broad. The state has no intention of asking about if he's won the Medal of Valor or something like that. The state will, however, ask about certifications when it comes to jobs within the Washington State Patrol and being authorized to carry out specific duties.
Okay,
and
so I'll stop you there.
I don't think that falls within what the motion is limited.
Right. Make an objection if you believe something inappropriate's been asked.
And number 16 is the last one that I plan to object to, as to the written motions. I have one other preliminary matter, but just briefly referencing 16 talks about wet labs. Right. I don't plan on going into any deep detail as to wet labs, but I will be asking the officer about their training and their experience and the type of tests that they had to pass in order to pass the academy. Wet labs will quite possibly come up. And this is, again, part of their standard training and education. And I believe that it's proper for the officer to reference it if it comes up.
Thank you. Ms. Moore?
I would maintain what is indicated in that in the motion. It sounds like the state plans to introduce I certainly have no objection to the state introducing credentials. It sounds like a wet lab would not necessarily have to be part of that.
All right. My view on that is that's just it's a factual matter as to what's presented in training. I've never heard the state argue that because somebody has performed wet labs, that somehow it gives scientific validity to some other determination they make. It's just part of the training experience. So I will allow it for that purpose. Of course, the state can't argue something beyond what trooper participated in.
Janet Sorbo, thank you for 4
and then,
months.
Just as one, two preliminary matters. Firstly, Your Honor, there's language that was used by the defendant in this case that it's offensive. I may directly quote it or reference it. And I just wanted to let that be known that I'm not doing this just flippantly. And yeah, so I was just advising of that. And lastly,
he's going to swear.
The defendant has absolutely no obligation whatsoever to testify. That being said, I would just ask for the court to instruct both parties to not reference anything in opening that they do not have a reasonable good faith basis to believe will be supported by evidence that is admissible and will be admitted into the record.
Okay, thank you. At this point, I consider both of you experienced counsel, so I think you both understand what's appropriate before the court and what's not.
Thank you, Your Honor.
Okay, any other issues to take up before we break till jury selection?
Not at this time from the state.
From defense, I think I would indicate to the state and the court that the state's made it clear that there may be some introduction of language. Defense may object to some such introduction on the basis that some of that testimony or evidence may be the prejudicial, the potentially prejudicial effect may outweigh the relevance.
Okay.
She's saying it's bad.
All right. I mean, if you want to make the objection now, we can talk about it now without the jury being here.
Yeah, let's do that.
Or you can wait till it's made during testimony.
Let's hear it. What are the words?
My decision issued in front of the jury. So, Ms. Moore, how do you want to handle that?
Probably prefer to proceed on that now.
Okay.
Without the jury.
I do have two.
So my thought on that is that in a case like an obstruction charge, it's important that the jury understand what the officer heard, so that in ascertaining whether it was just somebody frustrated or whether somebody taking a different approach. I think they need to hear the exact words that were spoken. So that would be my ruling on it.
Understood.
You haven't heard the words yet, Judge.
And I appreciate, I think you were smart to do it now, so I'm not giving validity to it by making that point in front of the jury. Anything else, Ms. Moore?
That was all, Your Honor.
Okay.
Well, he gave us he gave the prosecutor blanket permission to say whatever the bleep he wants.
Okay. We will meet back here at 2:00 for jury selection. Thank you, counsel.
Thank you, Your Honor.
Thank you. Appreciate y'all.
Yep.
Sorry, did the court just say what time?
2
o'clock.
Oh, yes, 2 o'clock.
That's 2 o'clock.
We'll see you back here at 2.
Thurston, Washington time.
Maybe 5 till 2. Okay, and and Ms. Moore, can you stand in on
Yes, I can.
Mr. Glaves?
Oh, I'll stay here then.
Okay, so that's something else. All right, I'm gonna record what happens. Let me go over here. I think we're done. I think we're done for the day. Judge Middleton just finished. Let me do a quick scan of where everyone's at. Middleton's done. 44th District. Judge Wolf is still going.
Yes, Your Your Honor, I acknowledge receipt of a copy of the indictment.
Stand mute.
Formal reading of the same and enter a plea of not guilty on behalf of the
Plea of not guilty is entered. We need to set a status date or a trial date.
Status, Judge, this is just her arraignment. 1/7, please, for status.
January 7th for status.
It's going to be a busy day. He's still setting stuff for that day. I don't know how these public defenders handle these cases.
All right.
They have so many of them.
Cody Allen Corbin. Mr. Corbin, is all of the information in your case on your affidavit true and correct?
Yes.
It shows you're not working anywhere. How long has it been since you worked?
Months.
How are you able to live if you're not working?
Living with my brother.
All right. According to his affidavit, he is indigent. Therefore, I'll appoint the public defender to represent him.
Here's the public defender. We're going to stand mute, waive formal reading, enter not guilty.
indictment, waive formal reading of the same, and enter a plea of not guilty on behalf of the
Plea of not guilty is entered.
January 7th, Judge, for status, please.
You want it on that January 7th?
Yes, Judge.
On the 7th.
January 7th for status. Make sure you stay in touch with your lawyer. Pedro Garcia.
These are all the individuals who said they were indigent. We saw him at the very beginning of the day. There's the same paperwork with his picture on the back.
Mr. Garcia, according to his affidavit, makes $800 a week at Arcosa Marine. He is therefore not considered to be indigent by the court and will not be entitled to an appointed attorney.
Has to hire his own. $800 a week.
His case is set for, we'll set him for October what day was that? October what? His case that we set for October 27th to give him time to hire a lawyer.
$41,600.
Show that he has been arraigned and a plea of not guilty is entered.
It's not a lot, especially when you have to pay for a lawyer.
Octubre 27. Sí, es la hora ahí, ¿no?
Did he fill it out right?
What time is he supposed to be here? On October 27, what time?
October 27th, 9 a.m.
A las 9 de la mañana. Okay. ¿Alguna otra cosa? Okay.
Thank you.
Thank you.
You may go.
All right. I think we're done for the day. Judge is wearing out as well. He's plumb tuckered out. He's been working all day long. I think we're done. So what I'll do is I'm going to record the proceedings in a little bit. Hopefully, maybe Josh can remind me. Record the voir dire, jury selection, and the openings for the trial up in Thurston County, Washington. We're going to watch that first thing in the morning tomorrow. That will get us up most of the way to the lunch hour, and then the trial's going to start at lunch in Washington. So, Sloth Life, thank you very much. Sloth Life, thank you for all those wonderful pins. I've been trying to pin your comments as soon as I see them posted, so I appreciate it. A comment on our on our replays with all the timestamps. So they're just super helpful. AZ Sun Devil 04, member for 22 months. OG says, I've learned so much about law. Best channel on YouTube and best recommendations from RA. Spicy maple bourbon pickles for the win. Those are so good. I had a jar of them 2 weeks ago. And by a jar, I mean I ate the whole jar in one day. And no, I don't eat the peppers inside, if you're asking. Those are too hot for me. They're not as fun to eat as the pickles. Debbie, living in the Pacific Northwest, has its advantages, definitely does. So, all right, that means that'll get us through tomorrow. It'll get us all the way to Wednesday, where the Soto case is going to pick back up, Soto de Escalara, with the sentencing. And we're going to return for that. The jury's going to be back to continue that case out of Florida. So let's see. So I know tomorrow is a holiday for some courts. We're going to be here. We're going to be working. It's not a holiday for us. So hope that's not a problem for anybody. Play on Crime. I love this space so much I cannot miss a day. Thanks so much for all you do in the mods too. Have a great evening. Play on Crime. Thank you. Thank you for being here. I think it's time to play some music. We'll let everyone go. I've got to start working on the gig that I have this weekend. You can start putting things together and charging batteries and checking cables. And basically, I have to build it in my name. It's not my name. I was reading this while I have to build it in my head. I was reading this comment when I said that. I heard my name. If I build it in my head, then I can build it on scene much faster because I know what the whole layout's going to be. Cables are important. Got 4 wireless mics that'll be handled. Need to run concourse views for the television of the concourse outside the little arena area. Not sure how to do that yet. I'll figure it out. I've got enough cables. I can make all of it happen. It's going to be good. All right, tonight when you go home, please hug the people you love. Smile at someone to make their day just a little bit better. Please stay safe till we go live again tomorrow morning, 8:45 or 9-ish, one of those two. We'll have a little court out of Thurston County, Washington to watch, and that'll get us prepped for Wednesday's court. Hump Day. Hump Day is the day after tomorrow. It's going fast. Polymac still stuck in the package, still scheduled to arrive today. Well, I tell you, my post office closes in 30 minutes, and it doesn't fit in the box unless it's really small. So I won't be able to get it till tomorrow at the soonest. So, yes, Thurston Court 4 is where we're going to be going. I'll record it tonight. We'll watch it tomorrow. So, check, baby, check. 1, 2, 3. Yeah, I need a good sound check. All right, you guys have a good night. We'll see you. Be good to each other. Have a good one. Bye-bye.
Because he's the guy.
I saw a chicken fight.
It's bigger than you. It's bigger than me. It's bigger than all of us.
In front of the Walmart.
What more do you need to see? Shame on you, sir.
There's nothing in the order that restrains you from talking to cats.
Thank you.
Hush! Now I'm trying to have court. You don't raise your voice again.